Have you ever worried about speaking your mind, especially when it involves sensitive or critical information, fearing it might lead to legal trouble? It is a common concern, particularly in fast-paced industries like sports and entertainment where reputations are everything. But what if certain statements, even critical ones, are legally protected? Yes, legal privileges can indeed offer a strong defense against defamation charges. These are specific legal protections that shield individuals from liability for certain statements, even if those statements might otherwise be considered defamatory. They recognize that in particular circumstances, the free flow of information and open discussion are more important than protecting individual reputations. The core mechanism behind these defenses lies in two main types of privilege: absolute privilege and qualified privilege. Absolute privilege provides complete immunity from defamation claims. It applies to situations where uninhibited speech is absolutely essential, regardless of motive. Think of statements made during judicial proceedings, such as testimony in court by a witness or legislative debates by lawmakers. These individuals can speak freely without fear of a defamation lawsuit because their roles demand it. Qualified privilege, on the other hand, offers protection under specific conditions. This means the statement must be made without malice, by someone with a duty or interest to communicate the information, and to a person with a corresponding duty or interest to receive it. For example, a sports agent providing a candid assessment of a client's performance to a potential team owner, or an entertainment executive sharing a truthful but unflattering review of a performer's work within their professional circle. The crucial distinction is the absence of malicious intent. So, how does this apply in practice? For absolute privilege, ensure your statements are strictly within the confines of judicial, legislative, or high-level executive proceedings. If you are testifying in court, participating in an official government hearing, or submitting a formal report as part of a legal process, your words are likely protected. For qualified privilege, focus on legitimate professional communication. Before making a potentially sensitive statement, ask yourself if you have a genuine duty or interest to share this information, and if the recipient has a legitimate need to hear it. Always ensure your statements are truthful, or at least made with a reasonable belief in their truthfulness, and avoid any personal ill will or reckless disregard for the truth. Documenting the factual basis for your statements can also be highly beneficial. An important insider detail is understanding that the scope of these privileges is not boundless. While a witness giving testimony in court is absolutely privileged, repeating that same testimony to a journalist outside the courtroom for a personal vendetta would likely not be protected. This highlights the critical importance of context and intent. Knowing these specific legal distinctions allows you to communicate confidently within your professional roles, understanding when and how your speech is legally shielded. For instance, an entertainment lawyer discussing a client's case with a judge is protected by absolute privilege, but if they publicly slander an opposing counsel on social media, that protection vanishes. Ultimately, grasping the nuances of legal privileges is a powerful tool for professionals in sports and entertainment. It empowers you to navigate critical conversations, make necessary disclosures, and engage in robust professional discourse without undue fear of legal repercussions. By understanding when and how these privileges apply, you can protect your ability to speak truthfully and effectively, safeguarding not only your reputation but also your professional responsibilities and the interests of your clients and organizations.